Welcome to the monthly Truck Stop webinar. This webinar is presented for members of the Motor Carriers Insurance Education Foundation on the second Thursday of each month, starting at 2 p.m. These webinars are for subject matters that are interested in for the industry and update on current events. It is not for CE credit. If you're seeking CE credit, contact our office. We do provide CE programs, webinars that do qualify for CE for 12 hours each year. These do not. If you have any questions during the program, please type in the chat window, and we'll attempt to answer them as long as we have time in the program. If not, we will email you the answers later, and if their questions are subject to everybody's information, we will then send it to share it with everybody on the program. If you experience any audio problems, please send us a note in the chat window or call our office again at 800-741-4084. We'll attempt to make any corrections during the program. We'll talk today about hiring drivers of trucks units with a 26,000 GVW rating, that's gross vehicle weight, or a GVWR rating, a gross combination weight, or larger, is the norm that we, the insurance providers, must deal with when we're providing insurance. Who are these drivers? This came up to me on a personal matter. I was sitting in the office of a construction company that my son-in-law operates, and I handle the insurance and other things in a little county northwest South Carolina called 6 Mile. We were going through the renewals in that, and they had a 1.5-ton truck with a GVW of 15,000 pounds. And I said, you know, that truck with a new reg, you're going to have a DOT number. My son-in-law said, yep, we just got stopped in Georgia. Cited for a number of items, including not having a medical card for the driver. He gave a whole list of things involved, from not having a DOT number, not having a medical card for the driver, plus he was looking at a couple other items where we had a light out and we did not have a tire that met the requirements. In that consideration, this driver in Georgia was very friendly to us and only gave us a warning, but told us we must need to get this taken care of. What I got focused on here is the driver criteria. He said the driver needed a medical card. I said, what? I know they do it for 26,001 GVW, and we have done webinars and done white papers and blogs concerning even the new medical registry involved. But for vehicles 10,001 GVW, not 26,001 GVW, you mean they needed a medical card? Might have to comply with other regulations also, such as Uniform Registration System and Uniform Carry Registration System. We've written blogs for the last couple of weeks on these, or last couple of blogs we've sent out on this stuff, but I thought that we'd also address this in today's webinar. So when registering regulations like this that I did not know about, I call my go-to guy, Scott Murray, who's here with me, and I'm going to do an introduction, then I'm going to pass it on to him because he knows far more about these subjects than I do. Very honestly, I did not know this, and I had talked to other agents who also did not know that these rules apply to drivers of vehicles less than 26,001 GVW, but larger than the 10,001 GVW. And this is where we're going to go today. Insurers who are not using large units and agents who provide insurance to them might not know these requirements as we did. Insurers don't know if they're compliant or not. Once they have to have a DOT number and get in compliance, then they're going to be subject to the CSA alerts and other items intervention and that could cost them more insurance. The other problem is that the government could step in and fine them and possibly put the units out of service. For example, if this officer in Georgia had wanted to be very aggressive in that area, he could have determined my son-in-law's driver to be out of service and be out of compliance, and would have put the vehicle out of service, and my son-in-law would then have to send a qualified driver up to Georgia to drive the truck back to South Carolina. That sounds easy until you realize that my son-in-law had no qualified drivers because he didn't know the regulations at that period of time. So it could be a real problem. So we're going to use against motor carriers, not going to be in court system lawsuits. For example, we've talked about this again at 26,000 GVW or larger, and we know that one of the things that plaintiff's attorneys first subpoena is the driver record files involving the driver qualification file, and involving a driver in a wreck. And if those are not at least in compliance, we end up buying more of the case. So this is what precipitated this particular session that we're going to share with you today. The foundation, the Motor Carriers Insurance Education Foundation, in large part focuses on for-hire interstate motor carriers. Many of our members provide insurance to users of commercial autos who operate vehicles much smaller than the tractor-trailers, the 18-wheelers. Many of these vehicles operate are not for-hire, or what is thought of as a for-hire private carrier. These include contractors, distributors, farmers, lawn maintenance, laundry dry cleaner, furniture and appliance deliveries. Anyone hauling anything in unit this size interstate could be a motor carrier by FMCIEF definition, which is anyone who uses a vehicle with a GVW or a combination of a power unit and a trailer with a GCW rating of over 10,001 GVW pounds for any business purposes in interstate commerce is a motor carrier under federal regulations. These units who cross state lines, again, hauling an item from Georgia, from South Carolina to Georgia as this was, or any other state lines qualify for this. So business whose name is on the side of the unit that has a GVW or a GCW rating of 10,001 or more and travel area is in more than one state has to meet these requirements. These businesses meet the FMCSA definition of a motor carrier, and as we discussed earlier, they might not think of themselves as a motor carrier. The insurance industry might not consider them as a motor carrier, but the FMCSA does. So it's 10,001 GVW rating. That's assigned by the manufacturer of the unit. Traditionally, this is 6 wheels. In fact, that's what I teach. But my friend Scott tells me these are pickup trucks, they're dualies, but in today's marketplace, some of the manufacturers even rate a vehicle with 4 wheels, depending on the size of tires, a rating over the 10,001 GVW. So the 6 wheels, the dually with passenger tires is normally what we look at, and that's the obvious thing that we see. But you need to check with the actual manufacturer, GVW, which usually is found on the side of the door, to verify exactly what we're talking about. But for this purpose, the visual one would be any unit with 6 wheels with a possibility of other smaller units. All users, private as well as for hire, meet this definition. It doesn't depend on who owns what's being hauled. It just depends on if you're hauling anything as a part of your business, interstate commerce, with a vehicle that meets this size requirement. If no DOT number, the unit is subject to being stopped. This is part of the Uniform Carrier Registration System that was effective October 2013. Now there's attention by the DOT officer. They have said, why do you not have a DOT number? Does the driver have their medical card? If they have a logbook, if over 100 miles from where the trip started, the vehicle lights work, other maintenance problems like tires. When stopped, could be placed out of service, then would have to send a qualified driver before the unit could be moved. These are the concerns that we would have. Question, what do you mean? My insurance not had to do this before. Yes, again, there's new enforcement. They've always been subject to this law, but to the registration requirement. But the enforcement was re-qualified in the Uniform Registration System was effective 2013. Why did this? This is called money. The government's looking at money. This is why you now have a new emphasis on the enforcement. Because once you have a DOT number, you have to pay into the Uniform Carrier Registration System. Those are the dollars. Those are the dollars that fund the federal government giving money to the states to enforce all the state regs and rules. Those funds apply to more than the for-hire carrier. The old system that some of y'all are familiar with was the bingo stamps or the single state registration system, which affected only for hire carriers. This new uniform carrier registration affects all carriers. So what was happening here, since there was a shortfall in dollars, the for-hire carriers were paying in it, and what the for-hire carriers industry says, don't make us pay more until you make everybody who has to be a part of this, meaning everybody who uses a vehicle 10,001 GVW or larger in interstate commerce must have a DOT number and must pay into the fund. So the enforcement was to increase the participation in the uniform carrier registration system to what it intended to do. And so that's why they're putting the emphasis on this, and the states are now stopping this because now they have to, because of the dollars that depend on that, how much they're getting. The second part here is that they overestimated the numbers of people with DOT numbers because nobody was enforcing the biannual update. So now the information that we find on the MCS 150 has to be updated every 2 years. And if not updated, then they're going to be put out of service, and therefore the system would be purged. So that's what was effective October 2013. This says everybody with a DOT number, who's supposed to have a DOT number, that's any user of vehicle, 10,001 GVW or larger, interstate commerce, would have to have a DOT number and pay into the fee, and they must update that information every 2 years. So why now? Uniform carrier registration funding started in 2005. The fees were shortened. There wasn't enough dollars. The enforcement part of the uniform registration system 2009 was the completion of that rule that started with the ICC Termination Act in 1996. This has been going on since 1996. The main purpose here is completion of the registration in one place and its fees to replace the single state registration system, which was generating fees of close to $100 million. That's the why that your smaller units are now having more focus to being stopped and having a DOT number. To that end, I'm going to turn the rest of these requirements, because we'll get into the requirements with my friend Scott Murray here, who will go through these processes. Scott, tell me a little bit about yourself and take off, my friend.
Well, thank you, Tommy. I appreciate the opportunity to be with you to share some rules and regulations that people who operate vehicles 10,001 or greater have to deal with. As you can see on the screen, I've been in this business for a while, and I don't know if the picture shows you or not, but it should show that I got white hair. And then that should tell you also I've been in this for a while. I worked in it basically all my working career. As a teacher, consultant, worked with trucking company, was with the South Carolina Trucking Association for many years, and now working in insurance, safety, and risk management. And the primary mission that I've used throughout my working career is to help truckers and other commercial vehicle operators understand the complex world in which they have to operate every day. And we want to also reduce the chance of accidental occurrence out on the highways, and we also work every day to find ways to reduce and improve safety performance. And certainly is to improve the bottom line. We try to work with everybody that wants to work and build those relationships and partnerships to make it happen. We're going to talk a little bit about, as Tommy mentioned, about the Federal Motor Carrier Safety Regulations for companies, drivers, and vehicles that have a gross vehicle rating, and we'll refer to gross vehicle rating as GVWR, of less than 26,001 but more than 10,001, and the other government requirements as we go through it. Federal Motor Carrier Safety Regulations will start, goes back to the U.S. Department of Transportation. I think everybody knows or is familiar with the acronym DOT. Well, this is a federal DOT, and they have had the responsibility since 1980 of having, for truck safety, enforcing truck safety in the United States. So when we say truck safety, we're talking about vehicles that have a GVWR 10,001 or greater. And then normally the regulations apply when you're, the federal regulations, when you're an interstate motor carrier who operate vehicles with a GVWR of 10,001 or more pounds. So as Tommy stated earlier, there is a plate in most vehicles from the manufacturer that states what the GVWR in pounds of that vehicle are. So if you're in question about a vehicle, open that driver's door, look on the driver's door or in that door sill, and somewhere there should be a manufacturer's metal plate or paper label in there that tells you what the GVW of the vehicles are. In addition, There are some more regulations that come in when you operate a vehicle at 26,001, but we're going to concentrate on the ones that are less than 10,000.
Yeah, Scott, this is what kind of confused me, because when I teach these classes, I'm talking about these 18 wheelers, a big truck, what you and I focus on. So I was kind of blindsided with my son-in-law's construction company, and I know that if we were, there'd be a lot of other people here. And very frankly, I don't think a lot of agents, insurers, and/or insurance companies pay attention because they might not know about this area.
Okay. And then, well, let's talk about, out of the federal regulations, what do they say a motor carrier is? And I think sometimes, Tommy, it's very surprising. Federal Motor Carrier Safety Regulations, and I'm speaking about Part 390.5, 49 CFR Part 390, talks about, it defines a motor carrier as a for-hire motor carrier or a private motor carrier. Well, we're going to talk about what's for-hire and what is a private carrier. That for-hire means a person engaged in the transportation of goods or passengers for compensation. You have a truck over 10,001, and you're going to haul my goods, my TVs, for me. You're going to transport that across the state line for a fee. Then you are an interstate for-hire motor carrier. Private carrier means a person or company who provides transportation of property, and some people do passengers, by a commercial motor vehicle. An example, your major manufacturing concern, such as Milligan Textiles, for instance, they have a fleet of trucks. They haul their own products for distribution between plants. They are considered a private carrier. But any user of a vehicle, 10,001 gross vehicle weight rating, GVWR, or gross combination weight rating, or larger, used in interstate commerce, and many times in interstate commerce in certain states. Intrastate, excuse me. We'll look at some requirements of these regulations affecting a vehicle 10,001 GV or GC. The business, it means the driver, employee, the company, and any company vehicles. They're all subject to the Federal Motor Carrier Safety Regulations. The company must register with the FMCSA by applying for a U.S. DOT number using the MCS 150 form. Just want to tell you at this point that will be changing in a couple of months and be phased in, but we wanted to make you aware. But the MCS 150 has been in effect for years, and what's in effect as we speak today. FMCSA regulations cover the company, the vehicle, drivers, and the amount of insurance dealing with those vehicles. Driver qualification files are extremely important. So it's a section on that, and we'll talk more about that in a minute. Vehicle maintenance files for the vehicles, driver's license, and drug and alcohol testing. Driver's hours of service come into play. Drug and alcohol comes in a little bit later, so we won't put an emphasis on that today, but just be aware it comes in at 26. Interstate motor carriers must pay additional items, such as Tommy mentioned briefly a little bit earlier, UCR fees, Unified Carrier Registration, and that's been in effect for years, and many times carriers are not aware of that, especially the smaller ones operating the smaller vehicles, and they get pulled over, and they will either get a ticket or a citation for that, and then they'll have to pay that to keep their authority or to keep registered. So let's just take a minute and sit back and say, okay, I operate that truck between 10,001 and 26,001. What all affects me? So we're just going to try to give you a snapshot of what goes on. Tommy?
Well, that's what I'm going to say here. For you who want to dig into the law itself, you can go into the FMCSA webpage. For you who are familiar with this, you can go into, if you look and go in Google Safer, look at the bottom part of Safer, where we pay attention to the first line in the middle column, which has snapshot and license insurance and SMS. If you look on the column on the right-hand side, the very top of that is FMCSA webpage. If you click on that, then you can go in and search for these regulations that we're talking about here and print them out. We're trying here to recap them. They're far more depth than we have time to go through here, but we want to make you aware of these things. If you have any particular questions, you can either email us about it, and Scott and I will attempt to answer, or you can go in and try to find the answer yourself. I just want to let them know where they can find this information. It's the FMCS webpage, and there's a link. There's ability to go into the Safer and then go into that column on the right-hand side to get this information, Scott.
So, Tommy, thanks. We briefly wanted to just expose you, if you're not familiar with this, of the parts that affect the truck operator 10,001 and over GV and GC. Part 390 of the Federal Motor Carrier Safety Regulations are their general applicability and definitions, general requirements and information. Requirements and information for intermodal equipment providers. Those are the folks that provide chassis for ocean-going containers. There's a section that deals with those. The National Registry of Certified Medical Examiners that come on a couple years ago is now in the Part 390. And then, as we talked about earlier, the unified registration, unified carrier registration. Part 391 of these regulations are probably the most important when dealing with insurance and companies, because it deals with who the motor carrier is hiring and putting behind the wheel. And of course, there's always an effort to try to pick the best candidates that you can, and there are certain minimum requirements. But Part 391 talks about qualification and disqualification of drivers. In other words, how you qualify them, are they qualified, and then if something changes, how you disqualify them is just as important as how we qualify them. It also talks about looking into the driver candidate's background and character, the physical qualifications and examinations, commonly called the DOT driver physical, and look at past files and records, employment records, and those kind of things. As we look a little deeper into 391 and the driver qualification file, each motor carrier shall maintain a driver qualification file for each driver it employs. Many times this is misinterpreted, but if you own the company and you drive a truck over 10,001 that belongs to the company in service to the company, you may be the CEO, president, principal, whatever the case, but under the rules, you are a driver. So you have to have a driver qualification file as well as anyone else who may drive those vehicles.
This is when we cross state lines that we're talking about here.
Yeah.
And so we got to distinguish between three things we got to make clear here. Just want to make sure we reemphasize this. We're talking about vehicles of this size that cross state lines for business purposes, period. No matter if you're private or for hire, whatever. There could be some other regs we're going to detail for intra-states, but we're talking about everybody now who crosses state lines must conform to here and must have this as a driver qualification file. Now, if they don't have that, obviously they could be put out of service, like I mentioned. My son-in-law will deal into that. Or if they have a DOT inspection and they don't have these files complete, then they could be subject to fines and dollars. Or thirdly, it could be used adversely in court. So this is why it's important that we develop this driver qualification file for those purposes.
Yeah, and I always say, being in compliance with the regulations, certainly we need to always do that. But I have a greater fear of not being in compliance with the regulations and then be involved in litigation, and that's really where it comes into play. So the more information we can give the public out there and customers about how and what they need, the better off we'll be. So let's just look at a driver qualification file to give you a bird's eye view of what needs to be in there. The driver's completed application for employment. And excuse me, Tommy, go ahead.
No, and now the thing here we say it must include a date of birth.
Yeah.
So here's where we make the first distinction between the EOC discrimination and from the safety regulations. If you have someone who's applying for a job that is not required to drive this vehicle, then you cannot ask their date of birth. But if they do qualify this vehicle, you have to ask the date of birth. It even could get down to an EOC problem depending on how you handle that age. If they drive the vehicle intrastate, you would not be able to ask their date of birth. But if they drive the vehicle interstate, you have to ask the date of birth. I use the term might not. Again, it depends on the state requirements we're going to get to later, but right and how the application, which means every insured you have has to have two sets of application. One application, or at least a supplemental application to their main application for things that meet the DOT requirements for interstate drivers here.
Yeah, a lot of people, Tommy, use an application that has been focused on the DOT driver employee, which has the additional information that the federal regs ask you to have. And I think most applications that I've seen in the past few years have that information, and people know that it is a good application and they can ask any of the questions on there that can ask that they be answered. As you said a minute ago, a date of birth, yes, the important thing, if he's traveling, she are traveling from one state to another, what we commonly call interstate, they must be 21 years of age presently. Now, there's some talk in Congress going on that they're going to lower this to 18, but that's not happened yet. So for the purpose of us today, if you travel from one state to another, you must be 21.
Not that this will not scare you already, Scott, in this area, but think about, folks, your insureds who are driving these vehicles here. who has to move something from 6 miles to Asheville, North Carolina, which is where we are right now, in Greenville to Asheville, that area, where you're talking about 30 miles. How many people would put an 18-year-old, a 19-year-old, the helper to take that load of lumber or saw in that 1.5-ton truck across state lines? That's the problem. They got to be 21 if they cross state lines. And so that's a division also. When you can ask the date of birth and the age here. So you need to even think about vehicles of this size. They need to be some kind of lines unless you're of this age and just have certain qualifications, which they could drive intrastate all they want to, meaning they can go from Myrtle Beach to Greenville, which is 300 miles at 18, but they can't go from Greenville to Asheville, which is 30 miles.
and certainly it boils down to who you put behind the wheel. Regardless of the age, you want to make sure they're competent.
Right.
And you just, as I use it many times, as I've taught over the years, would you put a driver that you don't know anything about in your brand new Chevy Corvette Stingray and allow them to go to California and back?
But the point that I'm making here is, though, they would be subject to fines and penalties if checked. And second is, we're now dealing with a court case, because now that driver who was 18 would not be qualified. You might end up, even in some cases, even the level of punitive damage, depending on how the case happens, depending on what happens. That's I was not aware of this distinction, Scott, and my concern and the reason we want to do this, I'm not sure that the people who are listening to us, or more important, their insurers and or their insurers know about this thing.
Right, and another part that they look at is the regulations require us to get a state MVR of the state that they're licensed in, 3-year MVR, and it really needs to be current, certainly no older than a year, and we need to look at that and make a determination on the 3-year record whether that might be a good candidate for us or not. And some of the other requirements in a bird's eye view is we want to look at least a minimum of 3 years of employment history, and you're going to check that out if you're the potential employer with past employers, if there is a history there, to make sure and size up that candidate for you.
I asked Scott this as we put this together. Well, what happens about my son-in-law, who these drivers already work for him? His comment is that they need to make a note in the file that they've worked for this company for 3 years. Continuous for 3 years to satisfy this requirement. If they have not, then they need to go back and verify that employment.
Yeah, if many times a company becomes aware of these regulations and they haven't done anything before, so they're delinquent in getting them done, but they're going to start today catching up with it. And as Tommy said, put a note in there that we've had this employee with us continuously for X number of years, and over a 2 or 3 year period or whatever, you sort of understand then how that employee is and what type of employee, what kind of work they do, how responsible they are, and all those things. And you simply put a note in to start with.
Right.
So we talk about the 3-year MVR, and then if it is a vehicle, we're talking about between 10,001 and 26,001. Between that, then they would have to have a road test, copy of the road test in there as another thing. And who does your road test? Do you just let anybody do it, or how do you pick who does it? And so you want to look and spend a little bit of time who's competent to do road tests to judge somebody else's driving skills. As we look further into the driver qualification file, new employment MVRs every year for the driver. In other words, after you hire the driver, every year you do an annual review, and you'll have to pull another MVR for that. And most states, since these are federal regulations, will allow the employer to pull those MVRs, and then they will list if they've had violations or not the current year, and then you'll review those, you'll sign off on those, and determine if that driver still needs to be qualified to drive your vehicles. And if there's something adverse there, then you might want to, this is sort of the process of disqualifying a driver.
For y'all who've been in some presentations we've done, you know that we're adamant that the insurance industry cannot provide that MVR. This is why it's an employment MVR, not an insurance MVR. It must be ordered by and sent by the employer for employment purposes, and the insurance industry cannot provide those MVRs to meet these requirements.
And you get the original one, which you go back a minimum of 3 years and that on their person, a copy of.
But we're going again. This driver that you have here might not be aware that they have to have a medical certificate. What we found in my son-in-law situation is none of their drivers have a medical certificate. They didn't know they had to. As of May 2 years ago, that certificate has to be done by someone on the medical registry. If you go back to the earlier pages through the FMCI's website, you can see the local people who are on the registry. Yeah. We were able to find somebody to be sent down there to get a DOT. And what you're saying is the driver has to keep a copy of that card in their possession, and the employer needs a copy in the file, correct?
Yeah, what you're saying is a couple of years ago they started in the process of saying anyone who does the DOT driver physicals must be a certified medical examiner. And there is an index on the website you go to verify who's doing your driver DOT physicals, that they are certified, and you verify that they are listed on that website. If you use a medical examiner that is not certified, in all cases, that it's not recognized as being a valid medical physical.
And when we get involved in this, again, we have the two concerns that Scott and I mentioned earlier. If the DOT officer comes and inspects you, or for some reason there's a reason to question this, if they don't have it, they could be put out of service on the roadside. If they do have it, it's done by the wrong people, they could also be put out of service on the roadside. They could be subject to fine. But again, if a crash, if an accident happens and something had to do with an accident that could have been divulged if they had done the physical, then we bought more dollars in claim time.
Yeah, and the physical thing is sort of in transition, the driver physical. We're going to where the certified medical examiner will have to transmit at the end of the second business day or the first business day results of that physical into a national database, and they will then notify the state DMVs, and that'll be put on their driving record. So we're in transition, but to be safe today, have your driver have a physical by a certified medical examiner, and be sure that they get a copy of it to their state DMV office, and that they keep a valid copy of that physical with them on their person as they travel.
That's if they have a commercial driver's license. Again, that part of it, as far as what we're talking about, the regs now and the clearinghouse now is in transition. So right now, what my concern is, as I found out my son-in-law, he had no physicals on any of his drivers. And again, here's a problem we have here is because if you pull physicals, there could be some how you do it, and you have to have it before you can allow them to drive, but that could be a violation of the ADA. So you've got to also consider that part of it also as far as your employment practice liability exposures and them not being physically able to drive.
Okay, and many times out on the road when a DOT enforcement officer pulls a driver over and asks for a copy to look at the copy of the medical card, they pull it out of a billfold or something, and it's dirty and it's dog-eared, it's smeared, they can't read it. So we want to emphasize that it must be a legible copy of that medical certificate with them on their person.
Our suggestion is to laminate it, give it to him, and you keep a copy in your office. If he's dedicated and only drives one vehicle, then my suggestion is also maybe to keep a copy of it in the vehicle itself, so that way he can find it.
And as we transition forward, having to have a copy on your person is going to go away.
Right, but that's a couple of years from now,
down the road.
But for particularly this level of vehicles.
Right. Okay.
And by the way, remember, that's what my son-in-law's driver was cited for, was for not having a medical card. This is what precipitated this whole webinar.
Yeah, and it's not uncommon. You have other folks. An example of this class of employee or employer is some folks that do landscaping service. They have a pickup truck and they pull a trailer and they have a couple lawnmowers, good-sized lawnmowers on the truck. Well, when you add, even though the pickup may be less than 10,001, when you add that trailer and the weight on that trailer to the GV of the pickup truck, it throws it over 10,000. So they're in this on an interstate level if they might be in an area where they jump across the state line. And we'll talk a little bit more about the intra.
Again, he's got to be 21, which is also to start the violation. And do they have the medical part of it in that area? And so that's the concern we have, is that depends on how close you're to the state lines. If you're sitting in Dallas, Texas, that's not a problem. If you're sitting in Charlotte, North Carolina, it is. If you're sitting in Newark, it is. If you're sitting in Texarkana, Texas, the city, the state lines, as you know, go right down the middle of the state, our city. So that's one of the things you have. What's your trade area? do you cross state lines or not? And then if you do, then you need to make these changes in your operations.
Okay, and then as we breeze on through bird's eye view again of the regulations that apply, 10,001, Part 392 discusses things about driving a commercial vehicle. Part 395 is a biggie, dealing with the driver's hours of service and proof of it. Many times we have to have proof in the cab by means of a paper log, or certainly electronic logging devices are coming in.
But you're not going to get electronic log devices of vehicles this size, because even though mandated law starts at 26,001 GVW. And so this is a major concern you have here. And a part of this is you need some documentation of where their regular reported location is, in other words, vehicles domicile, because when that officer that stops your insured to cross state lines, they don't really know how far, or they might not know where they started. So there's got to be some documentation that started. If it's the way the regs are, if the vehicle is less than 26,001 GVW and they're within 150 air miles of where they normally location, where they started, then they don't have to have a copy of the log with them. But if it goes over the 150-mile radius, though, they have to have a copy of a log that is current, meaning where they started up there. What I did with my son-in-law is I gave them a log book and said, if you're going beyond this area, you got to put down where you started and your drive time. Then when you load or unload, you're off duty and then come back, just so that if they get stopped, they have that log book here. So the point here is typically small contractors, or any contractor, but typically small contractors, delivery things that we talked about might not go over 150 miles. But every now and then they do. So sometimes they would have to fill the log out, sometimes they don't.
Yeah, Tommy, I think at this point we need to point out that when we talk about 150 miles, it is a person, it's what we're focusing on today, that does not have a CDL.
Yeah, they don't. No, the vehicle doesn't require a CDL.
Right.
We're only talking about things over 10,001. If
Right.
it's over 26,001, then it goes to 100 air miles.
Correct.
So there's a distinction between those different in that part of it. And that's also including agriculture, also that exception.
And there's a little bit of difference in the exemptions. So with the 100 air mile and the 150 air mile, we won't take the time to get into those. Just be aware of that. You can get into 49 CFR Part 395, and it talks a little bit more detail there.
But even if you don't have to have a log with you, there must be a documentation of their time at the home office, meaning a time card or other thing to verify that they did not work over the 11 hours, work over the 14 hours without taking a 10-hour rest. So the hours of service regs that you're familiar with, that we've talked about the restart problem and all those kind of things that have been a part of previous blogs and previous webinars that we have done, affects these vehicles 10,001 GVW. The only difference is that they have 150 miles where they don't have to have the logbook current with them, or less that has to be kept back in the office. That's the big difference here.
Yeah, and generally speaking, that's the way it is. And of course, we're all subject to the interpretation by the officer on the roadside, and sometimes they misinterpret the regulation, and that's where our industry has disagreement a lot of times. Right. But we always try to say that officer has the gun, that officer has the badge, and if it's a discrepancy and you do not agree, do not get into an argument or disagreement with that officer, and come on back to the company and we'll work it out.
And this is why I recommend, when this happens, that you have some notation so they can show the officer where he started or where she started driving that morning, so that they're within that 150 miles. That way you don't leave it, the driver, that then brings the officers to that attention here, and so that will verify here. This is where I started. This is why I don't think I was told I didn't need it, kind of word verbiage.
And sort of as a final point here with the 10,001 GVWR driver and vehicle, Part 396, which is beginning to take a more and more important part of this whole Federal Motor Carrier Safety regulations and compliance, is the inspection, repair, and maintenance of the vehicles that we run. And what goes on, as most of you probably are aware, is the roadside inspection process, where the feds send money down to the states to do the roadside inspections and enforcement on the roadside, and the vehicles are the second most reason that violations are written. First is usually the driver by hours of service, but the vehicles and those inspections are a problem also. So we shouldn't minimize the inspection repair, even on these smaller vehicles, because you got headlights, you got tires, you got brakes, you got certain safety equipment, the fire extinguisher, the 5BC. You have to have reflective triangles in the truck. You have to have spare fuses if the truck has fuses, and all those are writable offenses if the officer wants to make those.
Well, and in the case again on the Georgia officer, and thank goodness he gave my son-in-law some warning, not thing. We didn't have a current fire extinguisher, and it wasn't properly mounted if we had one. And so those are things that have to be worried about.
Okay, we've covered the gamut of 10,001 for just a bird's eye view, as I've said. Don't mean to keep repeating that. Let's just for the sake of knowledge here, say we do have a vehicle over 26,001. There are some additional parts of these regulations in 49 CFR that hit. Part 40 deals with procedures with workplace drug and alcohol testing. Part 382 are some more, or the controlled tells us how to do the controlled substance and alcohol use and testing, deals with all kind of things there. And then Part 383 deals with the commercial driver's license, which come in about 1990 or 91. And when you get a vehicle over 26,001 GVWR or GCWR, then these elements come in and attach to it.
So in this process, Scott, when you and I first talked about this, what we did is that the big difference is the drug testing, 26,001 or not, and the random drug testing and the
you got 6 types of drug tests you're subject to.
Right, where you don't hear. And so to boil it down for you that have been through presentations we've done who are used in this marketplace of 26,001 GVW, and we're giving you some basic overview. If you've got insurance that do this, you need to be aware of this. But everything that is required for 26,000 CDL above drivers is also required for 10,001, except for the drug testing and the Pacific driver's license called a CDL. That's the big difference in it. Everything else, as far as the age, as far as the application, the background verifications, the medical and all is the same, as long as it's over 10,001 GVW.
And sometimes when we're with the CDL, when we get bumped up to the CDL, then we have to do a little bit more investigation in the driver's background.
But basically, that's the big difference. That's the thing that I did not realize, that all these regs, because we only been focused on the bigger trucks,
right?
As this marketplace that we typically deal with does.
All right, so we talked about those. Let's just take a minute for the sake of trying to clarify interstate versus intrastate operation. If you'll see on the screen there, interstate operation, these regulations apply at 10,001. So if you're operating, as we said earlier in the program, between one state, what's commonly called interstate, these regulations apply at 26,001, most of the regulations. And that's GVWR or GC.
No, it applies at 10,001.
Yes. What did I say?
You said 26,000.
Oh, I'm sorry. At 10,001. And then if we look at some of the regulations come in a little bit later, as we just talked about, that 26,001. But normally traveling from one state to another, commonly called interstate, these regulations, majority of the regulations are going to hit you at 10,001. Gross combination weight rating is something else that we need to discuss briefly, and that is when the GVWR of the pull unit, commonly called a trailer, is added to the GVWR of the pulling unit. You add those two GVWRs together, and then you'll come up with what's commonly called a GC. If there's no rating, GVWR rating on the pull unit, then you should weigh that trailer and with the total heaviest loaded weight and add that weight to the GVWR of the pulling unit to give you the correct GCWR of the pulling unit. An example that we're showing is a pickup truck pulling the trailer. The pickup truck may have a GV of 9,500 pounds plus the weight of the loaded trailer, which is 5,000 pounds.
That could be 2 ride lawnmowers.
Yeah, it could be 2 ride lawnmowers on a little single axle utility trailer, and you add that all together to get the GCWR. It's 14,500 pounds, and they're under the regs, even though the pickup is less than 10,001. So you've got to be aware of that too. That catches a lot of folks when we get in there. GCWR gross combination, GVWR gross vehicle. A little bit of difference, just be aware of it. Interstate, again, talk a little bit more about the interstate and intrastate. Intrastate operations means operating totally within a state. In other words, if you're operating in Georgia, you don't cross the state line in Georgia, South Carolina, you stay in South Carolina, those kind of things. Not crossing that state line, not transporting interstate freight. So if the freight is determined to be interstate and you don't leave the state, you still will be considered an interstate carrier. An example of international freight is a shipping container that comes into one of the ports, and since we're in South Carolina, we'll say Charleston, you pick that container up and you pick it up in Charleston, you bring it to Greenville, South Carolina, you are in interstate commerce. It's not intrastate, even though you physically didn't leave the state of South Carolina.
But typically this marketplace for the smaller one, we could be dealing here with courier services or things like that, where they are interstate last mile delivery or things like that, these smaller units. Sometimes that's done, and they would have to still comply to the requirements for interstate.
And where some of the confusion happens is interstate, intrastate. The Federal Motor Carrier Safety Regulations, as we said, apply at 10,001 when you cross the state line. But then you got to look at someone who meets the definition of an intrastate motor carrier, when or if or does these regulations apply to them, and certainly they do. Now, some states have, the way they adopted the federal regulations, they adopted them to apply at 26,001. And what that means in layman's terms is if we are operating totally in South Carolina, for example, we don't cross out of South Carolina, we don't haul any interstate freight, then we don't have to worry about any of the items that we've discussed so far until we drive a vehicle that has a GV of 26,000 or a GC of 26,000. An example, North Carolina has pretty much.
But if I had a location in North Carolina, meaning I had one in South Carolina that was 26,001, but I had a location in North Carolina.
And you cross that line.
No, we don't cross the line. But now the operation in North Carolina would be at 10,000 GVW, so it would be different regs.
You would be considered, if you're corporately located in one of those and you cross it, it gets a little bit hairy about whether you're an intra or an inter.
Yeah, but if the vehicle never crosses the lines, then it would be, because you have different subjects. So when you deal with this, there's no uniformity. You also have to check with the state, because there's some states that have no regulations, about 8 or 9 or 10. Some states have it. The one thing here that we also teaches you some here, if they are subject to the intrastate, they'll have a federal DOT number, which gives us information in SAFER, and they'll have to update the 150 or be put out of service just like you would in others.
Yeah, okay. So I hope we've cleared up the interstate, intrastate a little bit. And I lastly wanted to talk about, and this is basically what Tom and I just discussed about operating, so you can take a minute to look at that, but we'll move on from that.
No. Now they've got to have a DOT number. You're going to have information in SAFER. And the concern I have here is, will the insurance carrier will use for non-traditional motor carriers, meaning that how many of your insurance carriers and how much attention do you pay for the units that are the contractors, all this? Do your insurance carrier now even look into SAFER to verify the information? Typically, we know it's this cardinal rule for the larger trucks we teach that application has to match with SAFER. And so now our concern is for these smaller units with this new awareness, with new requirement. Now they have to have a DOT number, information is going to be in SAFER. How many of your insurance carriers now are going to start paying attention to even the smaller units operations?
And many times, Tommy, there's not enough information on a smaller carrier or a smaller fleet that's under because they just don't get inspected that much or hadn't in the past. But if they are,
that's the concern here.
Yeah.
And if there's no DOT number, now they're subject to be stopped. And so now they're going to apply. So now for the people you're dealing with here, well, they don't have a DOT number now I got to. Then what they enter into is a new entry program of the FMCSA, which means that now they're going to get on the radar screen. Now when they make the notification, they're going to be part of the new entry.
Yeah.
So they're going to have some communication with the DOT officer.
Yeah, they will. Normally that program works within a year. They must make a visit to that business and verify that they are familiar with the regulations, they're in compliance with the regulations, and if they're not, they will assist them one way or the other. They'll get them in compliance.
And one of the things they're going to check out of compliance is the driver qualification file, like we just threw. And if they had not met all of that, they're going to be subject to some fines. Now, so far, the way I check in these states and all, checks and all, that the DOT officers are being relatively lenient in some of these.
And as we just talked about, within a year, someone's going to come. It could be a state officer, it could be a federal officer that come in to do it, and it might be an ununiformed state auditor from the state enforcement unit that comes in that does that communications on the new engine.
So now that I got a DOT number, I'm going to be forced to, because I cross state lines, I'm going to be subject to all this, but now I'm on the radar screen, I'm going to be inspected, and when they come inspect me, if I'm not having compliance, I could be fined. And so this is why you could add this value to your insurers by informing them of this.
And one thing, too, before we move on, after you get into a compliance review, which comes after a new carrier, you get a safety rating, and it's in the best interest of the motor carrier, big or small, that they have a satisfactory safety rating. They keep that up, because it all results into dollars and cents. And we want our people that we work with to be in compliance, and where our industry can work and take care of them as best we can, as most reasonable as we can.
And the part that we do these seminars, and for you who have been a part of the ones that I've done and Scott's done them with me, is the purpose of this seminar. We're going to touch very briefly with a couple other things about the Uniform Carrier Registration System. All motor carriers must comply. That means anyone 10,001 GVW larger. They must have the biannual update, and that's now being enforced through putting out of service. But here's the big: the common carrier contract had an MC number. Exempt and private had a DOT number. The MC number is going away. Now only the DOT number. So all for hire, including exempt, meaning cattle haulers, will be subject to regulations, and private carriers will be done. The only difference they're going to make in regulation is, are you hauling things that are hazardous, or if you're private and for hire, are you hauling things hazardous? Are you are you involved in moving and storage, or are you involved in hauling people? That's the only distinction in moving forward. And also, as a part of this, and here's the big thing, the financial responsibility filing. Anyone who needs MCS 90 on their policy now will end up having to have a filing. This is effective October 23rd, 2015, about less than 3 months from now, if it's put in force here. And reading the law, Scott, it says it's a drop dead date. It's going to happen. For hire, non-hazardous, meaning they haven't had a filing now. That's your cattle haulers, fresh fruit and vegetable haulers, your hay haulers, your chicken haulers will have to have a filing of $750 if it's non-hazardous. If it's hazardous, they're going to have $1 million, $5 million. A private carrier, non-hazardous, doesn't have to meet any requirement other than the state requirements, whatever the state requires them to have. In Florida, I'm aware of that. Florida is no more than 300,000. Texas is 500,000. I think Alabama's 100,000, 100, 350. States vary in that area. There's no requirement. But if they haul anything that's hazardous, now here's the crazy part of it. If you take a vehicle, 10,000, have a pickup truck, GVW of 8,500 pounds, a trailer with 2 lawnmowers on the back. Now we're over 10,001, correct? Does a lawnmower have gas in it?
That gets sticky. They call that materials of trade. And so they give you a little bit of a variance with materials of trade.
But if I have a can of 5-gallon paint, I have a 5-gallon
can of
gasoline on it to fill it up.
Then it depends on if you get a Barney or not.
Well, it depends on how I enforce it. But that says that I'm hauling any quantity of anything hazardous across state lines. I'm going to have a filing of at least $1 million,
right,
and a limit at least $1 million. Now, again, this is what the law says. We're still sitting here trying to figure out how it's going to be enforced and how long it's going to be enforced. But you need to be prepared that these smaller companies we're talking about now they have a DOT number. If they have anything that's hazardous, haul anything hazardous across state lines, they might be subject to having to have at least MCS 90 in inspection time, and in the foreseeable future, an insurance filing on their behalf, or they're going to be stopped and put out of service.
And one thing real quick, Tommy, if you're hauling flaggable amounts of hazardous material, such as the Class 1, don't want to talk about it much, but just want to mention, any size vehicle that's hauling flaggable amounts of hazardous material fall under the regulation.
Right. Well, pickup truck hauling dynamite or something like that.
Volkswagen,
right,
hauling dynamite.
Right. So you need to follow this.
Just be aware of that.
As we get closer to October 23rd, 2015, Scott and I actually did some research already today on that. We'll give you more information concerning these new regulations. The last thing, as Scott referenced earlier, the 150 form is going away. The new form is MSA-1. It's a 22-page form. Now, where the 150 is a 2-page form, but it encompasses all of this. So if your insureds are just private, they'll skip over some other areas. If they're for hire, they'll have these other things. But it does ask some more pertinent information, like who manages your company, who does your safety, who does your drug testing, who the ownership and management, or are they involved in any other, or have they been involved in any other motor carriers, and what are those safety ratings here? So there's going to be a whole lot more information that this new form is going to require the applicant to tell them about. How much of that's going to be available to us, we don't know. And the process will be, if you make a new application for a DOT number, you'll have to have the new form. One of my strong suggestions is that if you're insured, if you see that you're insured need a DOT number after this presentation, get it now. Get it before the MSA-1 becomes effective, because it's going to be much easier now, much fewer questions now, and then you'll be good until it has to be updated 2 years from now. So now's the time to get it, to encourage them to do it. With the new MCSA, if you make a new application, you'll have to, after October 23rd, 2015, again, going through the law, if it's implemented at the time frame they have set, you'll have to fill this new one out. Then if you already have a DOT number, then when you do your biannual update, you'll have to fill this out. So it's going to take us 22 months or so to get everybody on the same form. How much information will be available during that interim, I don't know yet, Scott.
Right. It's yet to be determined.
That part. We hope you all found out something about this. We welcome you here. We hope this is information with you. If you've got any questions or answers, we thank you for being a part of this. Our next webinar is September 10th at 2 p.m. We'll announce that subject matter as we get closer to the date. We're out of here. Thank you very much.